Well, thank you, Kevin, and thanks to Kevin, Mia, and the entire Marine Money team. It's a pleasure to be here with all of you and to share a few thoughts about where we are in U.S. maritime policy. I also want to give thanks to the governments of the United States and the People's Republic of China for keeping my life interesting, especially over the past few days. The topic is, where we are on U.S. maritime policy. And the risk whenever I speak about U.S. maritime policy these days is that I write up a slide deck and it's stale a few days after I write it. So I'll take pains to point out the locations where things have been updated since I finalized this presentation late last week. At a high level, this is one small piece of a much larger program that's being driven by the U.S. administration. It's driven by U.S. foreign policy and national security goals. So U.S. maritime policy is really just one aspect of many other developments that are going on currently between the U.S. and China and other markets around the world. I'm going to focus on what's the latest on the U.S. Trade Representative support fee proposals and some of the guidance that's been issued by Customs, as well as the modifications that have been proposed by the USTR on October 10th. And more broadly, what is the U.S. administration's goal here with respect to sanctions and trade policy? And then finally, where has OFAC been on the sanctions side? What are U.S. goals and priorities with respect to sanctions since January of 2025, including the issue of Executive Order 13902, which is an authority that's being heavily relied on by OFAC to implement its maximum pressure policy. The Section 301 fees that have been proposed and now implemented by the Office of the U.S. Trade Representative are probably very well familiar to everyone in this room. So some of my presentation here at the beginning is going to be a little bit of a refresher. It may be old news to people who have been focused on it for the last 6 months. But this has been in the works since the Biden administration with a petition for relief that was filed to the Office of the Trade Representative in March of 2024. That was filed by domestic trade unions, the Steelworkers Union and other unions, who effectively filed a complaint with the government and said that China is eating our lunch when it comes to shipbuilding. Chinese shipbuilding market share in 1999 was less than 5% of global tonnage, but it was over 50% in 2023. China has a dominant position in aspects of the shipping markets, including ship-to-shore cranes, intermodal chassis, and shipping containers. And so China's been engaged in a 20-year plan to increase its greenfield capacity, increase its vessel capacity, to build out its shipbuilding functions in the world. And it's really, there's no comparison with the U.S. fleet, which is effectively non-existent. It's much smaller than the international markets when it comes to shipbuilding in terms of Japan, South Korea, China. So what happened? There was a year investigation. There was the issuance of a report, and the Biden administration left it to the Trump administration to implement. And when the new team came in, you know what happened. There was $1 million per port call. There was no consideration of the sectors in which these fees would apply. And there were over 600 comments. There were 2 days of public hearings. There were 60 people who participated in those hearings in March. And in April, we had a much more considered proposal that began to put in exemptions and began to provide a little bit more nuance, although I think you could have debates about how nuanced it is, with the notice of action that was implemented in April of 2025. After that, there were hearings on certain aspects of the tariffs in May and June, and a deafening silence for the rest of the summer, because it left, the April notice left a lot of questions in the industry that people took a great deal of time to figure out as to whether it applied to their fleets. But there was very little guidance coming out of the Office of the Trade Representative or from Customs as to how that would be implemented. There are 4 annexes in the April notice that relate to Chinese vessel operators and quote-unquote vessel owners of China, vessel operators of Chinese-built vessels, car carriers and roll-on roll-off carriers, and then an LNG export scheme. And I'm going to focus primarily on the Annex 1 and the Annex 2 fees in this presentation because just due to the interests of time. Those were implemented this week. One thing to note about the Annex 1 fees under the U.S. Trade Representative's proposal is that the definition is very, very broad, and there are still unanswered questions about how broad to deal with it. With respect to the interpretive rules at the beginning of the annexes, it's important to note that there's only one fee that would be applied, and so they did segment it into different categories. If you're an LNG vessel, you are exempt from the fees. If you are a vehicle carrier, you're subject to Annex 3. Otherwise, you need to interpret Annex 1 and Annex 2 if you have a Chinese-built vessel or if you have links to China. With respect to the definitions under Annex 1, as I note, it was very, very broad. It includes entities with 25% or more of the voting interest, board seats, or equity interest held by any of the governments of China, Hong Kong, or Macau, or entities, residents, or nationals. It would include Hong Kong flagged vessels. It would include Chinese military companies like COSCO and CSSC. What they're intending to do here is to really cast a wide net, and I think it's been fairly deliberate that these definitions have not been really filled out with much guidance. The intent from the government is to create a chilling effect and to try to target Chinese shipbuilding capacity and promote U.S. foreign policy and kind of domestic manufacturing goals to rebuild U.S. shipbuilding capacity. So how does this work in practice? As of October 14th, if you fall within the definition of a Chinese vessel operator or a Chinese vessel owner under Annex 1, the operator would be on the hook for a $50 per net ton fee, which would be charged up to 5 times per year per vessel. That would be payable on the entrance into the U.S. customs area at the first U.S. port from outside of the jurisdiction on a particular string of port calls. Unless it's modified by contract, and BIMCO has published clauses about trying to allocate the risk here, the vessel operator would be responsible for calculating and paying that fee. And, with virtually no time to spare, Customs has issued, a payment mechanism through pay.gov to pay those fees. And so it would be the operator responsible when coming into port. If you had, for example, a Hong Kong flagged container ship, these fees go up over time. So if you get to April of 2028, $140 per net ton, and you do that math, you could be on the hook for $7.7 million per voyage, up to $38.9 million per year. Under Annex 2, a vessel operator of a Chinese-built vessel that would not fall within those definitions would then pay the higher of 2 methods, again up to 5 times per year per vessel. This is about half on a net tonnage basis, but in the container segment, I think there's notable concern that you could get up to $250 per container discharged, and at the higher of those 2 fees, that could be substantial over time. One thing that's not on this slide is that the U.S. Trade Representative issued a number of exemptions to ease the impact of fees on Chinese-built vessels. So, for example, short sea trading from the Caribbean is under 2,000 nautical miles from a U.S. port. That's a notable exception. It would be outside of Annex 2. Other exceptions include U.S. flagged vessels that are in the MSP or the TSP programs, and there are others. And also exemptions for smaller vessels or for vessels that are coming in empty or in ballast. But in practice, if you had a foreign-owned Cancer-Max bulk carrier that was a larger vessel, it was outside of the deadweight tonnage exemption, which is below 80,000 deadweight tons, then you would be on the hook for fees going up to $13.5 million for 5 voyages per year on a net tonnage basis for five voyages per year. Now, Annex 3 is being subject to modification as recently as October 10th. So this slide is already a little bit stale. In the prior proposal, it was based on CEU capacity, car equivalent units, but that was changed to net tonnage, and in the words of the government, to avoid manipulation of those figures, to make something that was a little bit more objective. But it's in an example of kind of how disorderly the last week has been, Customs issued guidance saying that the fee would be $14 per net ton, but on October 10th, when the USTR actually issued its modified guidance, they confirmed that it would be a net tonnage calculation, but it would be $46 per net ton. And so, one of the things that's interesting about the Annex 3 fees is that the whole purpose of the trade representative's mandate under Section 301 is to target a foreign country's unreasonable trade practice and then to take steps to address that practice. But Annex 3 is targeted at any foreign car carrier and not just China. And the U.S. Trade Representative has defended this by saying, well, this is a non-discriminatory measure and we're just going to apply it to the rest of the world. I think that could be subject to challenge. We know that there are also already challenges to the government's reciprocal tariffs from April, which are going to arguments before the Supreme Court in November. And this is under a separate authority, not IEEPA, it's under Section 301 of the Trade Act, but there are still potential challenges for people with a vested interest that they may make in the Court of International Trade. We haven't seen any yet. There are still open questions. I get questions frequently as to, what is the scope of the Annex 1 definition for links to China? How will those definitions actually be implemented by Customs and Border Protection? What about financing arrangements? A lot of folks have opted to restructure or refinance in response to these fees in order to ensure that they're minimizing their potential exposure. There's also been reports that, for example, C-SPAN reflagged a number of its ships and moved its headquarters to Singapore, again, to minimize links to China. I received a question from a reporter last week that said, well, can they get away with this? Yes, it's perfectly reasonable to restructure your operations in order to manage your risk exposure, your legal exposure to any new law. That doesn't mean that the laws won't change in response. Another question is, when does the year begin? And it's notable that the April 17th implementation actually was final agency action. So if a ship came in between April and October, it was charged a fee, and it fell within these rules, it was charged a fee of $0 under the notice of action. That may count as one of your 5 times per year. And that's not something that the government has actually implemented guidance on. Another question is, what will come next in the wake of these countermeasures that have been announced by China on October 10th and implemented, within 4 days thereafter? I think that's a wait and see moment. We can't really say exactly how it will play out, but we know that there are a number of cross-cutting arguments going on between the U.S. and China with respect to rare earth metals, export controls, all kinds of issues, and on upcoming meetings between high-level government officials. So there's a lot of posturing going on in the press and I think behind the scenes. There was guidance released by Customs and Border Protection within the last week on the USTR rules. On October 3rd, there was a guidance document, and I use scare quotes because I think the high-level takeaway is that, with the emphasis included, CBP said, look, the burden's not on us for answering all of your questions about this. If a vessel owes the fee, it's on the operator and not CBP. And so why is Customs and Border Protection effectively punting on this? The U.S. Trade Representative is responsible for the policy, and Customs is responsible for implementation. So Customs takes the regulations and the mandate from the U.S. Trade Representative's pronouncements. If the U.S. Trade Representative hasn't issued guidance itself, then it becomes difficult for customs to freelance and opine on what the policy should be. And if it doesn't have any internal guidance from the government, then I think that's why you're seeing a little bit of pushback from customs. They're just working on what the market has. There was also guidance issued by the ports of New Orleans and Houston. Again, this guidance incorrectly said that the Annex 3 fee would be $14 per ton, and it was issued prior to the U.S. Trade Representative's October 10th implementation of these modifications. And it just goes to show that, you've got in the background a government shutdown, a lapse in appropriations, and I think that there are people who know that these things need to be implemented by October 14th, but at the same time, they're dealing with a strain in resources and trying to get guidance out to people who've been asking for it since July. I think that one thing that's notable about the port guidance is that under Annex 1, the guidance says that the vessel owners will be determined by the vessel's registry and that the vessel operator will be verified through review of the COFR. Now, the COFR is an insurance document intended to protect U.S. ports against things like oil pollution. It comes out of the Oil Pollution Act. And it was also on the paper form that was referenced in the April notice. So I think that that's an important piece of information for people who are trying to determine whether they fall within the Annex 1 fees. But you should also note that ports can request other verifiable agreements, like a bridge letter or a continuous synopsis, and that's a nod to the fact that Customs has a broad scope of authority at the port, and they can look behind those documents if they suspect that there are links to China that aren't initially disclosed. And why is that important? Because although this is novel, Customs still has enforcement authorities if it's determined that someone's trying to evade or avoid these fees. Anytime you're coming into port and you're making a representation, it's the same as if you're getting off a plane and Customs asks anything to declare. You have to fill out the form that's been published by Customs, and it's important that those reports are truthful because there are provisions under U.S. law that the government could pursue or that a whistleblower could pursue to argue that you deprived the government of funds to which it was entitled. That would be under the U.S. False Claims Act. And there are whistleblower provisions under that act that could have substantial damages, including civil penalties, treble damages, and attorney's fees. I'm running short on time, but very briefly, I'd like to pivot and talk a little bit about where we've been on sanctions since January of 2025. With respect to Russia, it really is steady as it goes for U.S. policy on sanctions. There was a massive package of sanctions that was implemented in January of 2025, including secondary sanctions against all kinds of folks in Russia's military-industrial base. But I think, as was referenced earlier in today's panels, the EU and the UK are really taking the lead with respect to pressure on Russia for the ongoing war in the Ukraine. That includes the new sanctions from those jurisdictions against Lukoil and Rosneft. And that goes to the prospect of divergence and compliance challenges. If you're operating in multiple jurisdictions, you need to keep in mind which jurisdiction has the most aggressive sanctions so that you can comply with all of them. In China, again, there's a focus not only on the shipping industry, but on other aspects that are related to the U.S. national security. The U.S. is very concerned about things like semiconductors, artificial intelligence, and quantum computing. It's issued rules that are restricting outbound investment into China in those industries. Those are very broadly stated rules, and if you're a U.S. person, you have to notify Treasury if you're going to make an investment in one of those areas, and you may be prohibited from making certain investments in China's military base. It also applies to foreign funds that take capital from U.S. persons, because U.S. persons can't indirectly invest into those industries. There's also a data security program that's been implemented. That goes well beyond the shipping space, but it's an area of focus for the government. And I think finally, with respect to Iran, it was very clear from the very first day of the Trump administration that there would be a policy of maximum pressure and a return to the use of sanctions as a tool to pressure the Iranian government. And that is, it's been a drumbeat. There's been 8 rounds of sanctions that I count, at least, with respect to U.S. vessel, or with respect to vessels, and really the entire supply chain in third countries as well, that are related to the supply of of oil from Iran to China, and that entire trade. On that note, Executive Order 13902 and this will be my last point, is something that's been used in those rounds of sanctions, which are up here on the screen. The reason that EO 13902 is important is that it's a sectoral sanctions authority. And whereas previously the US government has applied those sanctions to any quote unquote significant transaction related to the supply of oil, now it's applying 13902 to any person who does business in the Iranian petroleum or petrochemical sector. So it really resembles much more of a sectoral sanctions program that had been traditionally used with respect to Russia over the past 3 to 4 years. So I know that's a lot of information. I hope it was helpful and interesting, and thank you again.